because I'm... Oh, hi. I have this meeting is being recorded. Great. Okay. Now, I can, make a short presentation and then take questions, Anna, if you think that's advisable, because I wouldn't know, of course, I don't know how many people are going to be there. I wouldn't know what they know and what they don't know. And perhaps what I will be covering is something that they are very familiar with. I don't know what they know and what they don't know. So I'll try and make an overview of the role of the court, the function, the role of the judges, the role of certain people in the court, registrar, and so on and so forth. And then I'll take questions. I mean, that should, cover more or less what I can contribute to this exercise.
That sounds good for us. I think maybe if you can see the room. Yes.
Right. I can see many people waving their hands over there. Yeah. Okay.
Yes. So around 15 people, I think.
Okay. And so not all the people there are necessarily legally qualified. Is that correct?
Yes, that's correct. Most of us don't have a legal background.
Okay. Okay. Then I'll go to basics as well, like the convention and so on and so forth. Fair enough. Okay.
Yes. Yeah, if you are ready, I think we can start.
Okay. Well, good afternoon, everyone. I have been asked to deliver a short presentation on the European Court of Human Rights, its function, how it works, what judges do or don't do on the European Court of Human Rights, and this to deliver this presentation to you as new interns, if I understand correctly, in this NGO. First of all, can I have from someone a brief idea of the nationalities that I'm addressing there? The background of... I know that the majority are not legally qualified, but can I have at least a vague idea of the nationalities of the participants?
We can give the computer to each and then we will introduce ourselves.
Yes, you could have a tour de table. Yeah.
Yes. So I'm Anna, I'm from Belgium, and I have a background in sociology.
In background in?
Sociology.
Sociology, okay, right. Bear with me, I'm a bit hard of hearing.
Good afternoon, I'm Christian. I have a background in international relations, recently graduated, and indeed, I don't have legal background. However, I have studied public international law and basic legal contents. But
and you are from?
From Spain. I'm from Spain.
From Spain, thank you.
Hi, I'm Paolo. I studied journalism and audiovisual communication, so I don't have the legal background. And I'm from the Basque Country, that is a region in the north of Spain.
Very familiar with that country, with that area. Yes. Yes, next one.
Hello, I'm Konstantin. I'm from Bulgaria. And my studies are in religious studies and English law.
Thank you. Right, great.
Hi, I'm Carmen, also from the north of Spain, and I studied social anthropology, so I don't have a legal background at all. Nice to meet you.
Same here.
Hello, nice to meet you. I'm Íñigo, also from the Basque Country in Spain, and I graduated in law, Spanish law. So
at least so you're fully legally qualified.
Yes, that's correct.
Great. Great
to meet you.
Good afternoon. Thank you for your time. I'm Eduardo, and I'm from Italy. I have a background in international relations, and now I'm pursuing with the masters in public affairs. And yeah, that's it.
Da quale città o regione?
Genova, in Liguria.
Non sono mai stato lì. Va bene, grazie. Thank you.
Thank you.
Hello, I'm Matilde. I'm also from Italy, and I study political science.
Okay, thank you.
Thank you.
Hello, I'm Bernat. I'm from Barcelona, and I study law and political science. So I'm
Great.
also one of the exceptions.
Yeah. Good afternoon. Nice to meet you. My name is Sumit. I study law and business. Hopefully, I'm finishing this year, so I have a little bit of law background also, but I'm not an expert.
You are reading law where?
Sorry? Spain.
You are reading law at what university?
It's a University of Las Palmas in Canary Islands.
Okay. So you're from Spain. Okay,
yeah,
thank you.
Thank you.
Hello, my name is Asya. I'm from Turkey and I'm studying languages, English and Russian.
Thank you very much. Right.
Hello, it's Cihangir. I'm from Turkey and I graduated from law school and I'm doing my master about health data and law and management here at University of Strasbourg.
Thank you. Nice meeting you.
Okay,
and that's Anna. Back to Anna. Okay, so let me launch. First of all, let me introduce myself. My name is Vincent A. Gaetano. I served for a full mandate of 9 years on the European Court of Human Rights. I was elected as judge in respect of Malta. I assume, but I won't have it against you if you don't know where Malta is. But before that, I was for 8 years Chief Justice in Malta, and for another 8 years as a judge of first instance. Before working as a judge for 15 years, I was a public prosecutor in the Office of the Attorney General in Malta. So my background is law. According to my wife, I have no hobbies except law, so that is not a very nice thing when you're retired. But as Anna has probably told you, now that I'm retired, I'm working full-time as Commissioner for Education in the Office of the Parliamentary Ombudsman of Malta. The office has 3 commissioners: Commissioner for Education, Commissioner for Health, and Commissioner for Planning and Environment. So these are the sort of segmented, the 3 isolated areas of expertise. Everything else, all the other complaints are handled by the Ombudsman. Now, the first thing to note about perhaps the European Court of Human Rights and the Convention, first of all, what is the Convention? The Convention was drafted, as I'm sure you know, after the Second World War. And the basic idea behind it was to make sure that the violations of fundamental human rights, which had taken place before, immediately before, in the years giving rise to, during, and even immediately after the Second World War, would not repeat themselves. That was the mission that the founding fathers of the European Convention on Human Rights had in mind. However, they realized that just as the League of Nations had failed, even the United Nations could possibly fail in ensuring this, at least within a European context. So they decided to have, apart from after, there was, of course, the Universal Declaration of Human Rights, but they wanted to have something which is enforceable. And this is the unique, and I say unique because there's hardly anything similar anywhere on the international scene, that you have a convention signed by, it used to be until recently, 47 states. Now it's 46 because Russia has been expelled. There is also an enforcement mechanism, which, by the way it is nowadays, was very, very different from the way it was when the convention first started. Some of you will know that, for instance, before the European Court of Human Rights, as it is nowadays, there were two bodies responsible for enforcement. There was the European Commission of Human Rights and the European Court of Human Rights. The Commission acted, I'm giving a very brief and general idea. The Commission acted as the vetting organ for complaints, whereas the court was the instrument to actually decide upon whether there had been a violation or not. But strangely enough, originally, the final decision as to whether there had been a violation of the convention or not could even rest in the Committee of Ministers, in the hands of politicians. Now, all that has changed over time. Everything has been transferred to the court. The vetting mechanism is done by the court through a procedure which I will try very, very briefly to explain to you. And so we have basically the court. Now, the purpose of the court is not to act, and this I would like to make it clear to you, the purpose of the court is not to act as a court of appeal, a final court of appeal, from judgments delivered by the domestic courts of the 46 member states. Very often you hear people say, well, I went to the, I went through the whole rank of courts in my country, let's say Italy, regional court and court of appeal, Cassazione, and so on and so forth. Eventually, I got nowhere and I appealed to the European Court of Human Rights. The European Court of Human Rights is not a court of appeal. It's not a court of final instance. It is a supranational institution which serves to ensure that the rights and freedoms guaranteed in the Convention and in the protocols annexed thereto are effectively guaranteed to people living within the territory of the signatory states, not to citizens of the signatory states. People, any person within the territory of the signatory state. Because if you look at the, well, I think it's Article 1 probably, it says that the signatories shall guarantee to everyone within their jurisdiction the following fundamental rights and freedoms, and then they are enumerated. So it's not a question of citizenship. It's people living within the jurisdiction. So what did they do? They created a supranational court. And this court has a very limited function. You might think, well, what about those thousands of cases, applications every year? Yes, still, but its function is limited. Its function is to ensure where there has been a violation by the state, by a particular signatory state, or by, obviously it's not the state acting as a state, qua state, but it is the officials of the state who normally breach the fundamental rights and freedoms. It is persons, people who actually act or fail to act in such a way as to breach the requirements of the convention. Where there is such a breach, this court will say so and also deliver a remedy. This is the only purpose. So its jurisdiction, in a way, is very limited. I mean, think in your own countries of the jurisdiction of the Court of Appeal. It covers everything: civil litigation, over property, over contracts, commerce, criminal proceedings, and so on and so forth. The Convention is the European Court of Human Rights, because it applies the Convention, is only interested in instances where there is a violation of the Convention. Otherwise, other things do not fall within its remit. So that is the first important thing to bear in mind. And in fact, as I'm sure you know, before a person can apply for the final redress of his fundamental or her fundamental human rights to the European Court of Human Rights, the person must have exhausted the available domestic remedies. In other words, must have gone through the domestic system. Now, there are some instances, including, for instance, in Malta, where the court has held that for a particular type of breach, there was no adequate domestic system. There was no adequate domestic system which could, in that case, the individual can go directly to the European Court of Human Rights. But of course, these are exceptional cases. In most cases, the individuals have to exhaust, as the expression is, that they have to exhaust domestic remedies. For this purpose, the framers, the drafters of the convention, created not only the convention, but part of the convention, after outlining, numbering the substantive rights to be enforced, to be protected, then they created the structure for enforcement, the court, the registry, how judges are elected, and so on and so forth. Those are the procedural provisions of the convention. One of the, when I landed in Strasbourg in, what was it, 2010, for me it was a shock. Remember, I had been a prosecutor for 15 years. I had been a judge of first instance for 8. I had been chief justice for another 8, 16 years in total on the bench. But still, the working methods of the court were something of a shock, because, you know, in every domestic system, I suppose your judges would, like me, take a case file home, read it, make notes, then start drafting, or nowadays typing on the computer, the judgment and so on. You hold sittings, you hear evidence, you hear witnesses, you hear arguments. The court cannot work in, the European Court of Human Rights cannot work in that way. There is, to begin with, the question of languages. So how do you overcome that? There is, besides that, the question of different legal systems. You have the common law system. It's true, not many. The United Kingdom, Ireland, to a certain extent Cyprus as well, which is sometimes considered as a common law country. But then most of the others are civil law countries: Malta, Italy, Spain, Germany. And they are totally different systems. I mean, the system of law in Malta is totally different, I can assure you, from the system of law in Iceland, for instance. So how can you manage such a court? This is where the genius of the drafters of the convention, they came in. They created a very strong registry. Now, the joke with judges, all judges over decades now, is that although the convention says there is a particular provision, don't ask me which one it is, but there is, I can assure you, which says that the court shall have a registry. The registry of the court is so strong that many judges say that it should have been the other way around, that the registry shall have a court. Because it is almost as if the registry and the registrar is more powerful than the court and the judges themselves. This is not true. But you have to have a very strong registry. The registrar and the people working in the registry of the court are the, how would I say, the depositories of the institutional memory of the court. And when you have a supranational court, which has survived all these years, from the early 60s. Forget the short period from when the convention was signed, and there was a period that they had to set up the commission and then the court and then to appoint judges and so on and so forth. Yes, fair enough. But from the moment that the court started functioning, the most important linchpin, the most important link, the most important aspect of the court was the stability of the registry. It is true, the registry is very strong in the court. And some judges, like me, coming from courts, domestic courts, where the judge is the boss there, and the registrar is simply an official assisting the judge. Some judges find this situation very, very strange. But for a supranational court, with so many languages, with so many distinct and divergent legal systems, a strong registry is a sine qua non. This does not mean that the final word rests with the registrar or the registry, far from it. However, they do a lot of work, the registry does a lot of work that we would normally associate with the judge or the judges or the magistrates in our own jurisdictions. So this is something that you have to keep in mind when looking at the court. Okay, judges are elected by politicians. Again, in most countries, because the election, as you probably know, for a judge to sit on the European Court of Human Rights is conducted by the Parliamentary Assembly of the Council of Europe. And the Parliamentary Assembly of the Council of Europe is made of politicians. Now, in most other jurisdictions, the final appointment may come from the head of state, from the President of France, from the King of England, if it's the United Kingdom, and so on and so on. But the actual selection of judges is normally carried out by an independent commission. In Malta, we have the Commission for the Administration of Justice. In the United Kingdom, they have the Judicial Appointments Committee, and so on and so forth. In the case of the European Court of Human Rights, it is, without any shame, stated that the judges are elected by the Parliamentary Assembly of the Council of Europe. However, once a judge is elected, he is not elected to represent his country, and this is very important. A judge is elected, for instance, I was elected the judge not to represent Malta, but I was elected a judge in respect of Malta, because what the convention wants to see is that every state represented, every signatory state of the convention should have a judge. So we do not represent our states. We do not, of course, we do not represent either the applicant. We couldn't, in fact, if, for instance, a hypothetical case, for me, it's a bit difficult to say because I never was in private practice. But had I been, before becoming a judge, before being elected as a judge in the European Court, to the European Court of Human Rights, had I been in private practice, I couldn't, of course, sit on a case where one of my clients, former clients, was applying for redress to the European Court of Human Rights, obviously. But neither do we represent the state, because in Strasbourg, like in most constitutional cases, you have a physical or juridical person pitched against the state. In constitutional redress proceedings at domestic level, the respondent is always the state. Likewise, before the European Court of Human Rights, the respondent is always one, or sometimes more, because as you probably know, there are some judgments which have been delivered in respect of more than one respondent state. like Russia and Cyprus, for instance, human trafficking, okay, several others. In that case, the respondent is always the state, but we do not, the judges do not represent the state, okay? That's the important thing. Secondly, there are within the court a number of officials who have special functions. Let's forget for the moment the judges. Let me speak very briefly about the other officials. Obviously, there is the registrar, section registrars, and many lawyers, whom we call agents, working within the registry. Some countries have even within the registry what is known as a division. In my days, at least, there was the Russian division, there was a Turkish division, the Bulgarian division, the Ukrainian division. Why? Because you had to have many lawyers from those countries to handle so many applications from those countries. In the case, these are what we call the high count countries. Malta, fortunately also for me, is a low count country. By the way, that does not mean that I had a very good time in Strasbourg doing nothing, because when you come from a low count country, you are immediately picked to serve many other divisions as well. I mean, I can tell you for many years, I was single judge for the United Kingdom, for Bulgaria, for Romania, for the Ukraine, and I was also single judge for a country which gave me much pleasure because I never had any one case to deal with, San Marino. So there I was quite happy with San Marino because I never had any problems with San Marino. But there are high count countries, low count countries, the registrar and the officials. Then there is the president of the court. The president of the court is the boss of the registry. The registry of the court acts under the general direction of the president of the court. The president of the court, by the way, is elected by the plenary of the European Court of Human Rights. Let me make this quite clear. What is the plenary? The plenary is all, used to be 47, now 46 judges sitting together, barely fitting in the biggest of the halls at the court, and in order to discuss not individual cases, but the procedures of the court, drafting the rules of the court. Occasionally, we had the fun in a very funny sort of way, of dealing with something unusual, like a request for the lifting of diplomatic immunity on a judge because his country wanted to proceed against him and his wife in criminal proceedings. You know, this was the case of the then Romanian judge. Allegedly, the whole thing was a politically motivated sort of persecution of the judge, but the plenary actually agreed to lift the diplomatic immunity of the judge in question. The Romanian authorities wanted to investigate the judge and his wife. His wife, by the way, was, I don't remember whether she was a judge or a prosecutor in her own home country, but she definitely had a judicial appointment, okay? So that is what the plenary does. The plenary does not, the 47 judges do not decide any individual cases. Going down in numbers, and this I'm sure you know this very well, from the plenary you have the Grand Chamber, which is the biggest judicial formation of the court, 17 judges, presided normally by the president of the court. If for some reason he is excused or has to recuse himself or herself, his place is taken by the vice president of the court. And then lower down, you have the chamber of 7 judges. Further down, you have a commission of 3 judges. And then further down the line, in numerical order, you have the single judge formation. There are lots of jokes about the single judge formation, because the most obvious joke is that the single judge can also be married in spite of being single, okay? But that's apart from it. Single judge formation is the one judge who disposes, and the most important nowadays, the single judge formation, not only nowadays, but even when I was there, is perhaps the most important formation because it weeds out thousands of cases, unmeritorious applications that end up before the court. If you look at the statistics, annual statistics, you will find exactly how many applications have been dealt with by the single judge formation, by a committee, sorry, I said commission earlier on, a committee of 3 judges, by a chamber of 7 judges, and by the Grand Chamber. The Grand Chamber is obviously the one that has the least number of cases decided every year, because the Grand Chamber has both an original and an appeal jurisdiction. So if there has been a decision by the chamber, if either the government or the applicant are not satisfied, they may seek to appeal to the Grand Chamber. But the appeal is not automatic. Why? Because there is another formation, another judicial formation, not very well known, which is called the Grand Chamber Panel. The Grand Chamber Panel consists of 5 judges. And this Grand Chamber, I won't bore you with the details of how it is composed and so on and so forth, but this Grand Chamber Panel actually gives, whenever there is a request for a judgment of the chamber to go before the Grand Chamber, it gives its permission or otherwise. It is like, those of you who may be familiar with, well, I don't know what happens in many jurisdictions, but certainly in the United Kingdom, for instance, to appeal, to go to the Court of Appeal, there is no automatic right. You appeal either by leave of the trial judge or else by leave of the Court of Appeal. In other words, the Court of Appeal must give leave for you to appeal. You make a prima facie case, and then the Court of Appeal says, yes, there is something to be said for an appeal, we'll hear you. Of course, they may then decide not to agree with you on appeal. The Grand Chamber Panel is the filtering mechanism for cases going from the Grand Chamber, from the Chamber to the Grand Chamber. As I said, nowadays, when an application is received in the registry, the first thing that is done is that there is a person called the NJR. Now, I wonder whether any of you have heard of the NJR. Have you ever heard of the NJR, or what NJR stands for? No. He or she is a senior member of the registry, and the actual designation is non-judicial rapporteur. The non-judicial rapporteur vets, of course not necessarily directly, but with the assistance of other lawyers, vets every application, and those applications which the non-judicial rapporteur considers to be unmeritorious, in other words, they're, complete rubbish, usually, or else they have been the subject of many cases where the court has, in similar cases, said, no, there is no violation. In that case, the non-judicial rapporteur makes a very, very brief report to the single judge, and the single judge then decides to throw out the case. But, of course, the single judge, because I said the registrar is very powerful, the registry is very powerful, but ultimately it is the judges who decide. The single judge may say, no, I'm sorry, I do not agree with you. This is not a case, this is a case which merits consideration. Now, in that case, the single judge may send the application either to the chamber, the 7 judges, or may send the application to a committee of 3 judges. Now, whereas, of course, a single judge, once he's single, all on his own, you can't speak of a majority decision. It's either yes or no. In a committee of 3 judges, the judges must agree on the outcome, either throw it out, or if this is a case where there is a violation, because you can go before the 3-judge committee, either for the application to be thrown out, or even for the application to be allowed and even remedy given. These are what nowadays are called the WECL cases, W-E-C-L, WECL. Well, let me try and remember what WECL stands for. I knew it. Anyway, they're WECL cases. I have my notes here, but I can't find the right meaning of WECL. WECL cases would be well-established case law, W-E-C-L, well-established case law, where the court has repeatedly said, yes, in this situation, there is a violation. Let me give you an example of WECL cases. In certain prisons, in my days, it used to be prisons in Italy and in some Central European countries, Central and Eastern European countries, where prisoners are kept in cells which were of a smaller dimension than established by well-established case law, then there was an automatic violation. Or else, Italy or Poland, for instance, I remember when I was dealing with Polish cases, where a criminal case takes more than 4 years at one level of jurisdiction. A criminal case starts, and then instead of proceeding slowly and being concluded within a year and a half, it drags on, it drags on. Once that the 4-year limit has been exceeded, the red card is up. In that case, a committee of 3 judges can find a violation, of course, provided the 3 judges are unanimous they agree about this finding. They can find a violation, okay, without having to go to the chamber. Why? On the basis of the well-established case law. All the work for the single judge and for the committee of 3 judges is done by the non-judicial rapporteur. If, however, the case is something more complicated and it's not thrown out immediately by the single judge, then it goes to the chamber. The first thing that the president of the chamber, now let me make a small bracket here. The convention speaks of chambers. The rules of court speak of sections, and there are 5 sections in the court. What is a section? A section is a larger pool of judges from which the chamber is drawn up. And if you look at the website of the European Court of Human Rights, you will find that, let me just check to make sure I'm not saying something stupid. I think it's here. I'll go here, sorry. It's this way. Yes, there are 5 sections. Okay, and because of the number of judges, not in all sections, the sections don't have the same number of judges. Normally, there is the majority of sections have 8 judges. No, sorry, 9 judges, but there is one of them that has 8 and one of them that has 10. However, it's not, you can never have a chamber of 10 judges. From those 10 judges, the section registrar picks by rotation always 7 judges, and it's those judges who form the chamber. Okay? And the chamber must always consist at least of the president of the section and the national judge in respect of whom or against whom the application is being directed. So if the complaint is against, I don't know, San Marino, in that chamber you must have the president of the section and also the national judge of San Marino. Incidentally, if the national judge is also the president, then the role of president is taken by the vice president. But these are technical details which, I mean, it took me almost 9 years to finally understand. It was only at the end of my career in Strasbourg I finally started to make sense of all these technicalities. But the most important, well, after the single judge, the most important formation is the chamber, which handles the not so clear cases. Now, sometimes the chamber can relinquish jurisdiction to the grand chamber. Why? If the case before the chamber is so novel, so new, or if the chamber is of the view that in order to decide this particular case, there has to be a departure from established case law, in order to avoid delivering a judgment in chamber and then possibly having another judgment by the grand chamber, which is different, the chamber may relinquish jurisdiction to the grand chamber. So the grand chamber has got an appellate jurisdiction, normally that's the case, or else a first instance jurisdiction if the chamber has relinquished jurisdiction to the grand chamber. And the grand chamber, you have 17 judges. Now, you may say, isn't that too much? Well, no, because considering the number of judges on the court, that is the grand chamber, and very often decisions of the grand chamber are very detailed, very in-depth. You may have sometimes a grand chamber where the majority decision is by just simple majority, and you have many separate dissenting opinions. As an example, for instance, of a case which was relinquished by the chamber to the grand chamber, I can mention the very, well, from my point of view, very famous case of Vincent Lambert and others against France on the question of whether stopping enteral feeding of a patient, enteral feeding, I'm sure you know what enteral feeding is, feeding directly into the stomach of a person who was paralyzed through an accident, but the person was quite alive. I mean, all his functions were working. The only problem that this person had was that he could not swallow from his neck. He could not eat properly. So he had to be fed enterally directly through the stomach. Whether stopping this procedure of enteral feeding would have amounted to a violation of Article 2 or 3, right to life, or inhuman or degrading treatment, and so on and so forth, of this particular person. It was a judgment where I was in the majority, because the majority said no, there would be no violation. 5 judges gave a very strong, lengthy, dissenting opinion. There was myself, the judge from Slovakia, the judge from Azerbaijan, the judge from, well, we were 5 in all anyway. Myself and most of the others came from Eastern and Central Europe. And this was a case where, of course, after the grand judgment, after the Grand Chamber, the French state had to grapple with a majority decision, a strong majority decision, because, only 5 of us dissented, but then also a strong dissenting opinion. And I must say, whether it's a good thing or not that this happened, this is not for me to say, but that the administrative courts in France, several of the administrative courts, eventually decided to follow the minority dissenting opinion, because this was a joint dissenting opinion. So the 5 dissenting judges didn't write separate opinions. We just pulled together over 3 weeks and decided to file a separate dissenting opinion. Incidentally, one of the features of a chamber, not the committee of 3 judges, because as I said, in the committee of 3 judges, the judges have to be unanimous in whether to declare an application admissible under WECL proceedings or totally inadmissible. But in chamber and in Grand Chamber, you can have separate opinions. Now, this is not always the case in many jurisdictions. In my country, for instance, in Malta, the biggest judicial formation that we can have is just 3 judges. And when I sat in the Court of Appeal here in Malta, I would preside both the first section of the Court of Appeal and the second section of the Court of Appeal. And if my wingers, the other 2 judges, happened to disagree with me, I would simply have to, nonetheless, read out the judgment of the majority. But I couldn't put in a separate dissenting opinion. In some jurisdictions, that is regarded as the best thing to do. Probably in Malta, it's the best thing to do because we're such a litigious people that it's better not to have too many separate or dissenting opinions. In Strasbourg, however, the convention provides for separate opinions, but only in the case of judgments, not in the case of decisions. Are you familiar with the difference between a judgment and a decision at all? Anyone?
Not really.
Okay. A decision is when the complaint, the application, is deemed inadmissible. Now, in that case, you can have a long, let's call it, judgment, explaining why it is inadmissible. But technically, that is a decision. And in the case of a decision, judges are not allowed to file separate opinions. It is only in the case of judgments, in other words, where the merits of the complaint have been examined and the complaint allowed or disallowed on the merits, not on questions of admissibility, okay? That separate opinions are allowed. That is very important. Who are the other functionaries, the important functionaries of the court? Yes, the rapporteur. Who is the rapporteur? Once a case has gone to a chamber, okay, it's channeled to the section. And there, the president of the section decides to appoint one of the judges as rapporteur, judge rapporteur. Now, normally, the judge rapporteur would be the national judge of the country against whom the application is filed. But you can very well understand that in the case of Turkey, in the case of Italy, in the case of Romania, in the case of Poland in my days, and Bulgaria and Ukraine, it was impossible for the national judge of these countries to be appointed rapporteur in all the cases coming against those countries. So, and that is why judges from low count countries, or let's put it this way, lower count countries, were very often engaged as rapporteurs for these countries, okay? What does the judicial rapporteur, now this is not the non-judicial rapporteur, which I mentioned earlier in connection with the registry. Now this is a judicial rapporteur. In other words, he is or she is the judge, okay? The rapporteur is the person who guides the case before the chamber. It's like, how many of you are familiar with the procedure in ecclesiastical tribunals? Anyone has ever been to an ecclesiastical, before an ecclesiastical tribunal at all? I doubt it. So in an ecclesiastical tribunal, where you have, especially on appeal, not on appeal, even in first instance, where you always have 3 judges, of course, the person, the judge who writes the decision is called the ponens. And then he submits his report to the other judges who can agree or disagree. This is the function of the judicial rapporteur, of the judge acting as the rapporteur in any one particular case which is before the before the chamber. Even in the grand chamber, you have to have a judicial rapporteur. In other words, one of the judges who guides the case, who gives instructions to the case lawyer, who puts questions to the government, questions in writing, you know, to have the case well instructed, l'istruzione del processo, for those of you who speak Italian, okay, l'istruzione del processo. And in that way, the judicial rapporteur then presents the case either to the chamber or to the grand chamber. The chamber, the judges in the chamber or the judges in the grand chamber may agree or may disagree. Sometimes they may agree with the outcome. Yes, this is a violation, or this is not a violation, but may disagree with the reasoning, in which case very often the section would say, the chamber would say to the judicial rapporteur, look here, can you come up with a better judgment, with a better reasoning over this or that case? And that is why sometimes cases are also delayed before the chamber or the grand chamber. I'm not sure I have much more to say as far as the proceedings are concerned. Separate opinions I've mentioned, the Grand Chamber panel I've mentioned, the national judge. That's it. So this is basically the procedure before the European Court of Human Rights. Now, all this is, as I said, for a judge who has just come from, in fact, to be honest, you know that in order to be appointed as a judge at the European Court of Human Rights, you have to have either served in a high judicial office in your country, or, as the convention says, you must be a jurisconsult of international repute. Normally, in fact, we've had sometimes judges who have never served as judges in their home country, but who were either lawyers or academics. My predecessor in Strasbourg, the one before me, in other words, Giovanni Bonello, a very Italian name, but he's Maltese, was never a judge. He always refused judicial appointment in Malta. When he retired, the court made the unprecedented, his colleagues, in other words, on the court, took the unprecedented step of collecting all his separate opinions, concurring, dissenting, partly agreeing and partly dissenting, and so on, and published them in a book called The Right to Dissent. No, sorry, When Judges Dissent. When judges, in other words, do not agree, because he was brilliant as a judge on the court. He was a brilliant lawyer, a brilliant human rights lawyer, and especially his the way he wrote, and with tongue in cheek very often, was something that, I mean, his separate opinions were literary masterpieces. If you want to see a particular example of his separate opinions, I would advise you to go and look at the judgment of Lao Tzu and others against, or Lao Tzu and another. I'm not quite sure whether it's and others or and another. I think it's Lao Tzu and others against Italy. about the use of the crucifix in classrooms in Italian schools, okay? Now, that was a case where a chamber of 7 judges, the president at the time was Baroness Françoise Tulkens from Belgium, decided that there was a violation of Article 2 of Protocol number 1 of the Convention, that children attending classes in an ordinary Italian school were being indoctrinated in the Catholic religion because of the presence of the crucifix in class, which is a requirement of the Concordat between Italy and the Holy See in respect of Italian education. When the judgment was delivered, all hell broke loose. Not only did Italy request referral to the, in other words, to appeal to the Grand Chamber, but 12 other signatory states of the Council of Europe intervened in the appeal, asking also to have the case referred to the Grand Chamber. And the Grand Chamber, not unanimously, by the way, I think it was 13, 14, 15, 14 against 3, overturned completely the judgment of the chamber. Now, in that case, Judge Giovanni Bonello was in favor of overturning the judgment. So you might say, well, he did not need to write a separate opinion, but you can write a separate opinion even if you concur with the judgment. And his judgment began more or less with this expression. Of course, it was a dig at the chamber, at the composition of the chamber and its presidency. He wrote something to the effect like, it does not become an international court to succumb to historical Alzheimer's. And then he went on to show how, you know, the political life, the political calendar, the social calendar, not only in Italy or in many other countries, but even in France, the most secular of states, okay, is actually follows the canonical calendar, the calendar of the Catholic Church. And it's this type of judgment, this type of separate opinions that made him either famous or a bit of a thorn in the side, depending of which side of his barbs you happen to be. But this is to show you that judges can come, some brilliant judges, can also not have served as judges in their home country. When I was there, I think that there was also the Irish judge who had never been a judge in her home country. She had been a professor. There was also the Slovenian judge, if I remember correctly. The majority would have been judges, but there were several others who were not judges. So this is the function of the judge on the European Court of Human Rights. Now, I've talked for too much, for too long. Now, I would like to know what you are interested in, rather than continue talking about things that I think I am interested in, or I think you might be interested in. So please, I would stop here and ask you, or indeed beg you, to put questions if you have any. Don't feel constrained, by the way. Thank you, Anna.
Yeah. Okay, I will give the laptop to the person who has questions. Yes.
So my question was regarding your relations with the execution department of the Committee of Ministers. Do you follow the case after the judges? Do you work together with them for the execution of the cases? You follow them? I don't know what's the job you do together with them.
Well, as a judge, as an individual judge, the only way one follows it is because one is interested in ensuring that the judgment is, let me take judgments against Malta, my home country, okay, is actually executed. Now, the execution of judgments usually involves more than one aspect. I mean, if it's simply the award of pecuniary damages, pecuniary or non-pecuniary damages, then in 99% of cases, not only in Malta, but all other countries, including Turkey, including when Russia was a member of the Council of Europe, all the countries immediately give the pecuniary damage to the applicant, to the individual, the money. Okay, that's not a problem. What is usually, where the problem usually arises is when the judgment, either of the chamber or of the grand chamber, require a modification, a change in domestic law or in domestic practice. Aha, that is the problem. That is where normally you find the, what's the word in English? When you have a low, when the water is very low. Anyway, you're on the ground, in other words. Sorry?
I think you mean shallow, maybe?
Yes, the water is shallow, you're on the ground. That's where normally, where the executions are on the ground. Now, invariably, however, the executions department, which works for the Committee of Ministers, has developed over the years a very good system of coaxing, gently pushing, in other words, a country to do what is necessary to be done. It may not be done immediately, but over some years, it will get through. And I think, I don't have statistics about the execution of judgments when this problem is an issue. Because as I said, the question of awarding the compensation is never an issue. The question of paying the lawyer is never an issue. No. But when it is amounts to changes in either law or practice, yes, that could be an issue. But in the majority of cases, the executions department, in other words, the Committee of Ministers, through what we call peer pressure, on the country, manages to get that done. I think the only real stumbling block in execution is in the case of interstate cases. I haven't spoken about interstate cases. Normally, there are, well, not normally, there are two types of cases that you can have. Either complainant or applicant against the state, or a state against a state. Those are the only. Now, interstate cases, I have to admit, this is my opinion, by the way, don't take me as gospel truth. In my opinion, in the court in Strasbourg is ill-equipped, very much ill-equipped to handle interstate cases. Interstate cases take up a lot of time, a lot of resources, and very often the outcome of an interstate case remains in the balance for years and years and years. And there have been, fortunately, there have been very few interstate cases. You can think of, I don't know, Cyprus against Turkey, or Georgia against Russia, or Georgia against Azerbaijan, for instance. In most of those cases, because of the high political element, but remember, the number of interstate cases decided over so many years, or even still pending, can be counted, well, I can't say on the palm of two hands, I would probably need another palm. I mean, there would be 15 in all or something of that sort. Very few and far between. They are politically sensitive. Recently, I think it was last year or the year before, there was a case of a number of countries bringing an interstate case against Russia It included, for instance, the downing of that KLM flight over Ukraine, which allegedly was shot down by a Russian missile. Now, that was an interstate case. Now, tell me, how are you going to enforce, especially now with Russia excluded from the Council of Europe? How are you going to enforce it? Okay, you might say it's a Pyrrhic victory, maybe. But in the normal cases, AB against a country, okay, the execution rate, it's a bit strange to call about execution rate because it means almost killing someone, okay? The execution rate is quite high, and the statistics speak for themselves. Do the judges follow the execution with the execution department? Yes, we follow it out of interest only. There's hardly any other reason for doing this because that is a political decision. It's out of our hands now. Okay?
Okay. Thank you so much.
You're welcome. Any other question?
Yes.
Sure.
I have one, if it's okay.
Yes.
Yeah,
yes.
go on.
Well, thank you very much for this training, by the way. It was very informative.
I'm seeing only someone who's not speaking, actually. Who are you?
I'm on Zoom. Can you hear me?
Yes, I can hear you, but I can't see who you are.
Oh, okay.
Because the camera or whatever the computer is
okay. Yeah, I'll turn on my computer. Oh, sorry.
Okay.
So as I said, thank you very much for the informative training. So I have one question regarding the principle of subsidiarity. Mm-hmm. So as we know that this principle means that the state has the best position to implement the convention. But my question is, like, does this principle also undermines the control of the court? Like, for example, like the countries Turkey. Now we have a judge, Saadet Yüksel, and she keeps using this principle and saying that Turkey has like the best position to determine if it's implementing the convention. So I was just wondering if this principle undermines the convention or the control of the court.
This principle doesn't undermine as such. I will not be dragged into trying to make a judgment, pass judgment on past judges, much even less on serving judges. So now, every judge brings with him or her his own background as baggage. Okay? His own background as baggage. That, however, does not undermine the jurisdiction of the court, and neither does the principle of subsidiarity, because the principle of subsidiarity is inherent in the very function of the court. The court will only take cognizance of a case if the person has exhausted domestic remedies where those domestic remedies exist and are deemed to be effective. If, from the experience of the court, as happened in the case of Malta, for instance, in immigration cases, expulsion of illegal immigrants, if the court comes to the conclusion that a particular country, in this case Malta, did not have a credible system of deciding, for instance, immigration cases within a reasonable time, then the court will say, you don't have to go through the domestic system. You can go straight to Strasbourg. That is because subsidiarity is not a sine qua non. It's only if there is an effective remedy at domestic level that you must exhaust. You mustn't go, you cannot be forced to go there if there is no remedy, for instance, you see? Or if there is no effective remedy. The remedy available at domestic level is illusory. It's theoretical or illusory. Now, the principle of subsidiarity is important because, first of all, from the point of view of the state is obliged to correct, and normally a state would prefer to correct a violation of fundamental human rights at home, rather than to display, as we say, the dirty linen abroad, okay? So That is, it's a benefit. In fact, we have a situation now in Malta. Let me give you this situation. Malta has signed and ratified Protocol number 12 to the European Convention on Human Rights. Now, what does Protocol number 12 deal with? Anyone remembers what Protocol number 12 deals with? I see a gentleman here on the camera. The computer is. Do you remember what Protocol number 12 deals with? No. Protocol number 12 establishes the right of freedom from discrimination, not only in the enjoyment of fundamental rights, but also in the enjoyment of any other right available in one's country. Because for discrimination, or rather against the discrimination in the enjoyment of fundamental human rights, there is already Article 14 of the Convention. Fair enough. This protocol, however, establishes the principle of non-discrimination in the enjoyment of any right. Now, not all countries have signed and ratified this protocol. The United Kingdom has only signed it, not ratified it. Malta, however, wanting to be more Catholic or more holier than the Pope, decided to sign and ratify this, and that protocol came into force in Malta now 10 years ago. To this day, the government in Malta has not yet transposed Protocol number 12 into the schedule of the European Convention Act, which means that the domestic courts, the local courts, and we've had a judgment recently to this effect, the local courts cannot apply Protocol number 12. Why? Because we follow the dual system of law, like in the United Kingdom, that a convention, an international instrument that is signed and ratified, does not automatically become law unless and until it is transposed by legislation into domestic law. So what happens if if the local courts are not able, because the government does not want to transpose Protocol number 12 into the schedule of the European Convention Act, the local courts are not able to apply this protocol. The next time that there is a violation, or even in this particular case that the court decided in Malta that it could not give a remedy because it cannot apply Protocol number 12, the individual may next time, or another individual obviously, can actually go straight to Strasbourg, because there is no domestic remedy for a violation of Protocol number 12 in Malta, you see? And of course, this is a stupid situation, because if you have, let's say, an alleged violation of Protocol number 12 by, I don't know, a government department or by an agent of the government in Malta, the most sensible thing to do would be to have the local courts decide upon it. Less expensive for everyone. Okay, the applicant will get his costs covered by the court. But the state would have to send an agent to plead the case in Strasbourg. Why all this hassle? You see? Now that is a clear example where one can bypass the question of subsidiarity. Why? Because there is no effective remedy in this case. I don't know whether I've answered your question or not. Of course, you were hitching on, linking to what a particular judge says every time and so on. But ultimately, the case is not decided by one judge. It's decided by all the other judges. So if the majority agree with this particular judge, it means that there must be some substance to that argument. If they do not agree, it's the majority which decides the case, not one judge, even if that judge happens to be the national judge or the rapporteur. Okay? Any other questions?
Thank you.
Yeah, I had one question also.
Yes, you've been waiting there on the side. Yes.
Exactly. Well, firstly, thank you very much for your time. It's been a really informative talk, yeah. And well, it's a pretty broad question, so there's some space for freedom to answer it. But it's what do you think, especially with the constantly changing political landscape that we have now and the progressive decline sometimes of multilateral institutions, especially now in the Western countries? What are the main challenges that the European Court of Human Rights is facing right now? And if there are some mechanisms or some initiatives being or steps being taken in order to try and fix them?
This is not the first time that the European Court of Human Rights has faced the crisis, and that the alarm bells started ringing, or the red flag, or the red card. No, not red flag, because the red flag is associated with something else, but at least the red card or the yellow card was shown by member states of the Council of Europe to the court. When I landed at the court in 2010, the most vociferous country against the court was, believe it or not, one of the countries that actually drafted the European Convention on Human Rights, the United Kingdom. If you look at, for students of comparative law, if you look at the convention, it is totally made up of principles of English law, because the main drafters of the convention were English judges and jurists. Okay, there were others from other countries, from France, for instance, from Germany, but the main ones were British. When I landed in court, there was this attitude of anger by members of parliament. I remember Theresa May, who was Home Secretary at the time, ranting against these European judges and not making a distinction between the European Court of Human Rights and the European Court in Luxembourg of the European Union. They had absolutely no idea of the difference, believe it or not. And I remember one case, Abu Qatada against the United Kingdom. This was it was decided, I was sitting at that court, it was decided in chamber, it never went to grand chamber. It was about the return of, yes, he was a hate preacher in England, okay? The return of this person, Abu Qatada, to his home country in Jordan, where he faced trial by a military court on charges which were supported by the torture of third persons. In other words, the evidence against Abu Qatada had been obtained through the torture of third persons. Now, the court, the chamber where I was sitting, found one, that the military tribunal in Jordan would probably have been even fairer than if he had stood trial in the United Kingdom, because the military setup in Jordan, because Jordan follows the military setup of the United Kingdom, practically. Okay, so we're talking about military courts. And military courts in the United Kingdom are very fair. We found no problem with that. The issue was, if there is such abuse of authority by a country that they manage to extract evidence, let's take, what's your name, by the way?
Bernard.
Sorry?
Bernard.
Bernard. If you were, for instance, let's take a country which is you are going to be tried in Russia, Okay, normally if you've committed a crime, you should be tried in Russia, even though Russia is not a member of the Council of Europe. But if there is evidence, clear evidence, that the evidence that it is going to be brought against you has been obtained through the torture of someone else, a third party, that is a flagrant denial of justice. You will be denied justice because the evidence is completely tainted. And this was the whole issue that was determined in Abu Qatada. Theresa May could not see this. For her, the European Court of Human Rights was blocking the return of a hate preacher to Jordan. And in fact, the court, in our judgment, what we had said was that he could be returned to Jordan only after the British government obtained diplomatic assurances from Jordan that that evidence would not be used. Then he was sent back to Jordan, and in Jordan he was acquitted by the military court because the Jordanians kept their word. You see? That was when the United Kingdom started piling pressure to try and get out of the human rights system. And they haven't, they have stopped to a certain extent, because even under Boris Johnson, they stopped. Now, fortunately, with the Labour government, the pace has been reshaped. But there are other countries, as you said, other countries in Central Europe and Eastern Europe, we have the war. And what is worse, we have also a backlash from far-right organizations and politicians and so on, who unfortunately would prefer to see almost a fascist system. I mean, and this is the problem with a court that tries to steer a middle way. Whatever you decide, you either get it from the left or you get it from the right. And it's always the same. This is not the first time that the court has been in, or people have said that the court has been in crisis. The court has had a checkered history that has survived many ups and downs. To begin with, when the court was established, the problem was that it took about 5 years for the first case to be presented to the institutions, to the court institutions, because everyone was afraid. And in those days, the right of individual petition was only adopted, I think, out of the 8 or 10 signatories of the original signatories, only half of them had the right of individual petition. The others didn't have. So over the years, because the Convention and the European Court of Human Rights are only as good as the governments who support the Convention are, period. Okay? Now, Miss Ince, I think, is from Turkey. Is that correct? You are from Turkey?
Yes, I am.
Yes. Okay. I mean, you may have a jaundiced view of Turkish politics at the moment. But remember that even Turkey has had a notable tradition, especially Turkish judges, of independence. Now, it's up to those judges to stick to their guns. First of all, in the home country, and then eventually, if they are elected to either the European Court in Luxembourg, no, because Turkey is not a member of the European Union, but in other fora. But Turkey has got a very reputable tradition when it comes to its legal system. And so does Hungary, for that matter. So does Poland. So does the Ukraine. And other countries as well. I mean, if you want to look at it that way, it's the smaller countries which have no leverage on the political scene that don't really have any real strong background like Turkey has, or like Poland has, or like Hungary has. I mean, I'm thinking of countries like the Principality of Monaco, which has its own judge, or the Republic of San Marino, or Liechtenstein, for instance, or Malta, for that matter. In Malta, we have a tradition of independence going back to 1800, to when we kicked off the French occupiers, and unfortunately we asked the British to take over, and they liked it so much that they stayed for 164 years here in Malta. So, but anyway, so I'm not particularly worried about the European Court of Human Rights. The European Court of Human Rights has managed to adapt and adopt a number of systems, a number of survival systems, without compromising its core function. Without compromising its core function. There may be individual instances where you might think, but the court was leaning backwards in this particular case. Yes, I've come across occasionally those cases. During my tenure, I noticed that, especially with cases against the United Kingdom. The court, the judges, but deliberately, would try and find some modus vivendi, to ensure that if not a full violation, half a violation is found, to suggest remedies and so on and so forth. It worked because, let's face it, the court in Strasbourg is the creation of politicians. It began with politicians. The judges are elected by politicians, and the execution of its judgments is not left in the hands of the court-martial or the ushers or of judicial police, la polizia giudiziaria or something like that, but is in the hand of politicians, the Committee of Ministers, the ministers par excellence of the Council of Europe. So I'm not particularly worried, but then I'm an incorrigible optimist. So you have to take that into consideration as well. Any other question?
Yes.
Yes, please. You're from Spain, is that correct?
That's it, yeah.
Yeah.
I have a couple of questions. Like the first one is related about what we were talking about, the executing of the judgments, and it's also related what you were talking about the UK, because I think there is another case that is so similar about the Rwanda immigrants that were in the plane, and I think the European Court made cultural measure or something. I think it's called like that, and they didn't allow the UK to get the immigrants outside of the country. And after that, the politicians of the UK, as you said, were promoting a law that says literally that the politicians of the UK don't have to take into consideration the European Court of Human Rights announcements.
I've heard of that, but I don't think that law has actually has actually come into force, as far as I know. I don't know this particular case you're referring to, but certainly what I remember is that when the issue was first raised before the Supreme Court in the United Kingdom, in other words, the domestic court, the judges stopped the deportation of, at least the initial ones, certainly, I don't know what happened afterwards. I lost it in the fog of, with the fog of many other issues, international issues, but certainly the first decisions of the Supreme Court, that's the top court, like the Constitutional Court of the United Kingdom, was that the deportations were to be stopped precisely because there was no guarantee of the safety of the persons being deported to Rwanda, in Rwanda. So I'm not quite sure what the factual situation you are referring to is, and I don't want to pronounce myself on facts of which I am not clear. You see, as far as I know, the law which was intended to exclude judicial review of such decisions was not passed in the United Kingdom, as far as I know. If, of course, judicial review is not possible in a domestic setting, then automatically you don't have to try and exhaust that domestic revenue. You can go straight to Strasbourg on an issue of fundamental human rights. So I'm sorry I can't answer your question as clearly as perhaps your other colleagues, but I have to make sure I know the facts of the case first.
Yeah, of course. I think like the law was like promoted by 2 months, but now the Prime Minister of the UK like went back to the path of cooperating with the European Court of Human Rights, and he like pronounced that that was a mistake of the UK, and that's it. So now they are already again with the trying to cooperate with the European Court.
You must distinguish what you read or hear in the newspapers between what was actually proposed initially and what actually took place. As far as I know, this law that you're mentioning was never brought into effect. I think, if I remember correctly, it ran aground in the House of Lords, because in the United Kingdom you have the House of Commons and the House of Lords. If my memory serves me right, and very often at 73, my memory does not serve me right, I'm afraid. This law that you're mentioning did not pass through the Lords. Okay, and so, of course, the government could repropose it. I mean, that much I still remember from my English constitutional law, but probably the present Prime Minister decided to backtrack, fortunately.
Yeah. I mean, it was like an example of another.
You mean to say someone who has shifted shifted route, took a different route? Yes, well, politicians do. I mean, what do you call that thing that goes round on the roof indicating the direction of the wind? A weathercock. I think it's called a weathercock. I mean, most politicians are like weathercocks, so they change direction very often, sometimes too often.
Yeah, of course. Yeah. My second question was about the judicial situation in Spain. Okay, because now, personally, I believe like in Spain, the Supreme Court and the Constitutional Court are also elected by the politicians. Mm-hmm. So, personally, I think this is a system that is not quite.
Who are elected by the politicians? Is the Supreme Court? Is it?
And the Constitutional Court.
And the Constitutional Court, yes, okay.
Yeah, they are both elected by the politicians, but the assembly. Yeah. So, I personally believe this is like not a really neutral way, because one of the principal values of democracy is the independence of the judges. And I can see, for example, in the European Court, you have like a more neutral system because
in the European Court, you mean in Luxembourg or in the European Court of Human Rights?
No, European Court of Human Rights. I'm referring.
Okay.
Like you're first elected in your home country. Three, as you said, like 3 proposed candidates, and then in the assembly, there's only 1 elected. But I think it's more neutral, like that way. And Spain is
that is the system that has been chosen by the drafters, the framer of the convention. By the way, it wasn't always as fair until 20 years ago. The government was not required to put the names of the 3 candidates in alphabetical order. The government was allowed to put its preferred candidate first and then the other 2 underneath. So it wasn't always that fair. Yeah. Nowadays, the Parliamentary Assembly requires, yes, or an alphabetical order and so on and so forth. But the fact that someone is appointed or elected by politicians, I come from a country where until 11 years ago, or even less, 10 years ago, all judges and even the Chief Justice were appointed by the cabinet, by the Prime Minister, in a sense. That is it, provided that the person or persons you appoint are, how would I say, there's in the superlative, integerrimi, in other words, of utmost integrity, okay, and do their job properly. The fact that you're appointed by politicians, even the fact that ultimately the appointment comes from the head of state. For instance, I think there was a French case, for instance, where someone said that he could not receive a fair trial because the judges of the, I think, French Court of Cassation or something, are all appointed by the President of France. I mean, the court in Strasbourg send the applicant packing, and they dismissed the applicant because someone has to appoint. The problem is how to ensure that the choice is correct. At the moment, here in Malta, we have a constitutional crisis. Nowadays in Malta, judges are selected by a special commission, an independent commission, and 3 names are proposed to the President of the Republic, who, in choosing one of these 3 names, does not act on the advice of the Prime Minister, but in his, or in the case we have a woman, in her own individual judgment. And that has worked quite a lot, and it's better than the previous system where the Prime Minister would agree with the Minister of Justice that, I don't know, that INSE is going to be appointed I'm looking at you because you are the only 2 on my screen at the moment. INSE is going to be appointed a judge. So the Minister of Justice phones INSE and says, look here, we want to appoint you as a judge. Do you accept? And she says yes. And she's appointed a judge. The present system is much better, but there is a catch. This applies only for judges and magistrates, by the way, because we have the English system of magistrates and judges, lower courts and higher courts. But for the appointment of the Chief Justice, the Constitution now provides, when I was appointed Chief Justice, I only received a telephone call from the Prime Minister, who was on holiday at the time in his, by the seaside. He wanted to speak to me. I was terrified because I didn't know what was going to happen. I thought I had made some big mistake, something, as a judge. We already had a month and a half previously. We had 2 judges, the Chief Justice, my predecessor, and another judge arraigned in court on charges of bribery. Everyone was in a state of despair, all the judges and magistrates. So when you get a call early on a Saturday morning that the Prime Minister wants to see you at his summer residence by the seaside, I mean, all hell breaks loose. Fortunately, I managed to drive safely because I was terribly worried. And he simply blasted at me that he had the Cabinet's approval, that the Cabinet wanted to appoint me as Chief Justice. I tried several times to dissuade him because, honestly, I would have preferred to remain a judge of first instance, sitting in my own court, not having to deal with 2 other judges in a collegial court. In trials by jury, we have the English system of a trial by jury and so on. But he insisted and ultimately pulled the carpet from under my feet. He said, well, if you don't accept, then in that case, I'll have to find a Chief Justice from outside the present complement of judges. Now, in order to limit collateral damage, as we say, as the military would say, collateral damage, I told him, yes, well, I'll consider then accepting. I had to go home. My wife was in hospital. I had to go to hospital to consult my wife. Of course, my wife was no help. She told me, well, you decide, it's your questions. And I accepted. Now, that was the way. Nowadays, the Chief Justice is appointed by a resolution of Parliament supported by at least 2/3 majority. So it's not a simple majority, 2/3 majority. However, at the moment, government and opposition can't agree on a replacement to the current Chief Justice. The Chief Justice, his term of office has expired a month ago, but he's still in office because that's what the law says, that if he's not replaced, he can remain in office. But of course, he would like to retire. He's tired as well. And we don't know what happens if he were to retire. The constitution is silent. So now the two political parties are bickering between them, burning bridges, instead of trying to build bridges, burning bridges to gain brownie points, one over the other. So here you have, what appeared to be a very good solution, Parliament agreeing by a 2/3 majority, like they agree for the appointment of the ombudsman, for instance, parliamentary ombudsman, in whose office I serve as a commissioner. But sometimes it doesn't work,
Yeah, it happens the same in Spain. Like, we're still waiting because the Supreme Court has all the judges have not been re-elected, so they are extending their period. It's happening almost the same. So that's why I was questioning a little bit about the system we have. But
yes, but fortunately, and remember, before obviously being elected, the three judges on the list are actually grilled by a subcommittee of the Parliamentary Assembly of the Council of Europe. And I can tell you that grilling is something that I won't pass through again, because they really grill you about what you've done, how you would think you would decide a particular case. What do you think of, like, the doctrine of the margin of appreciation? What do you think? Do you think that the court is too proactive and too invasive, and so on and so forth? They really grill you. So they do their work. And then their report is sent to the Parliamentary Assembly of the Council of Europe. And generally, the recommendation of the subcommittee is acted upon by the Parliamentary Assembly of the Council of Europe. So yes, the judges on the court in Strasbourg are appointed by parliamentarians, but after a good grilling and with a lot of background checks. So, okay.
Okay.
Any other questions? I think we're almost. Are we running out of time? Have we run out of time, Anna? You guide me, please.
Thank you so much for your explanations. It was very helpful for us. But for now, I think we have to finish this session. Yes.
Thank you very much indeed.
Yeah, thank you so much.
Yeah, thank you.
Thank you so much, sir.
Thank you. Thank you. You're welcome. Bye-bye.
Bye.
I can switch off, press some button over here, and supposedly I will go offline. I'm not sure what I have to do here. Let's try this one. Leave meeting. Yep.
Yes.
Okay, bye. Bye.
Ahora,